Sir Alan Bates, the man who spent more than 2 decades fighting for justice for sub-postmasters, told MPs that the compensation schemes themselves had been an utter disaster. That criticism should concern all of us. If victims at the centre of the most high-profile miscarriage of justice in modern Britain are still struggling to obtain fair and effective redress, what does that say about compensation for miscarriages of justice more generally? The uncomfortable reality is that many people who successfully overturn wrongful convictions face an even greater problem. Not delayed compensation, not inadequate compensation, but no compensation at all. In this video, we will examine how compensation for miscarriages of justice works in England and Wales, why so many exonerees fall through the cracks, the reforms that have been proposed, and what the Horizon scandal can teach us about what society owes people when the justice system gets it catastrophically wrong.
Welcome to Spoken Injustice, where we put the criminal justice system in the dock. In the past 2 videos, we have examined miscarriages of justice in considerable detail. We have explored the causes of wrongful convictions, the dynamics of manufactured crime, the devastating consequences they have for those affected, and the many obstacles that stand in the way of correcting them. As we have seen, identifying a miscarriage of justice is difficult enough. Persuading the courts to overturn a conviction can be even harder. As we continue to connect the dots, today we turn our attention to what happens next. What happens when a conviction is finally quashed? What happens when years of legal challenges, appeals, and campaigning ultimately succeed in overturning a conviction? Many people assume that this is the point at which the story ends. The conviction is gone, the individual won their appeal, justice surely has been done. Well, not quite. For many exonerees, overturning a conviction is not the end of the struggle. In some cases, it marks the beginning of a new battle, the battle for an apology, redress, and compensation. Recent comments by Sir Alan Bates about compensation for victims of the Post Office Horizon scandal provide a timely reminder that even after a conviction has been overturned, obtaining meaningful compensation can be far from straightforward. After all, many people assumed that once the convictions were overturned and compensation schemes created, justice had finally been achieved. Yet, this is what Bates recently told MPs.
This question is for each of you because the experience that you have may be different dependent on your groups. How confident are affected groups that the compensation schemes will deliver outcomes that are proportionate and just?
I think, if I can say first off that post office schemes are often described as compensation, whereas the GLO scheme, something I went through, it was actually meant to be a financial redress scheme which included a proportion of compensation. It was meant to put people back in a position they would have been in had Post Office not done to them what they did. So I know compensation sort of wraps it up. It's become the common way of describing it. And the other thing I'd like to add is that, any comments I make today are very much my own views, but they're also based upon my experience of being a victim and also leading the group over all these years. I think if you ask me what do I think about the compensation scheme as such that have been involved for the Post Office, I'd have to say they were utter disaster, to be quite frank. And there are just so many reasons why they were wrong and why they've caused so much grief even nowadays.
Drawing from that, perhaps we should ask a more fundamental question. Why did the government create entirely separate compensation arrangements instead of simply directing Horizon victims towards the original miscarriage of justice compensation scheme? Let me tell you why. Because under the ordinary statutory scheme, overturning a conviction is only the first hurdle. To obtain compensation, exonerees must satisfy a further legal test which effectively requires proof of innocence. In other words, in England and Wales, it is entirely possible to be sufficiently innocent to have your conviction quashed, yet insufficiently innocent to qualify for compensation. That is one of the reasons why dedicated compensation schemes were established for Horizon victims. And it raises yet another difficult question. If the ordinary compensation scheme was not considered suitable for one of the largest miscarriages of justice in British history, is it really working for everyone else? And that is the issue we will explore today. We will look at how compensation currently works in England and Wales, why so many exonerees are excluded, what reforms have been proposed, the campaign being led by Appeal, and what the Horizon scandal can teach us about what justice should look like after a wrongful conviction has finally been recognized. So if you haven't already, consider subscribing to the channel and join me as we explore this controversial yet very important issue. So imagine spending years in prison for a crime you did not commit. You lose your freedom, you lose your job, your finances collapse, relationships break down, you miss birthdays, weddings, funerals, and countless of ordinary moments that make up a life. Eventually, after years of appeals, campaigns, endless CCRC applications, your conviction is finally quashed. Most people assume compensation follows automatically. Well, no, it doesn't, because there is a crucial distinction between overturning a conviction and qualifying for compensation. After being exonerated, Brian Buckle found himself fighting for compensation.
I was refused compensation in 2024 for not being innocent enough.
To understand why, we need to look at the current law. We have dealt with this issue in greater detail in this video, but for the purpose of today's video, it suffices to say that compensation for miscarriages of justice in England and Wales is primarily governed by Section 133 of the Criminal Justice Act 1988. At first glance, the provision appears relatively straightforward. It states that compensation may be paid where a conviction has been overturned or a pardon granted because a new or newly discovered fact demonstrates beyond reasonable doubt that a miscarriage of justice has occurred. On a common sense reading, that might seem uncontroversial. If a conviction has been quashed because new evidence has come to light, surely that is enough to establish that a miscarriage of justice has occurred. Unfortunately, is not quite that simple. The position changed significantly in 2014 when subsection 1ZA was sneaked into section 133. This provision sought to define what constitutes a miscarriage of justice for the purpose of compensation claims. It states that a miscarriage of justice exists only and only if a new or newly discovered fact shows beyond reasonable doubt that the applicant did not commit the offence. That addition fundamentally altered the compensation landscape. The crucial point is this: having your conviction overturned does not automatically entitle you to compensation. Successfully challenging a wrongful conviction is only the first hurdle. To qualify for compensation, applicants must satisfy a separate and much more demanding test. They must show that a new or newly discovered fact demonstrates beyond reasonable doubt that they did not commit the offence. In practical terms, this amounts to a requirement to prove innocence. So a conviction can be quashed on the basis that it is unsafe, yet the individual may still be unable to satisfy the statutory compensation test. In other words, it is entirely possible to have a wrongful conviction overturned and still be denied compensation. Those in favour of the current scheme point out that convictions can be overturned for many different reasons. For example, due to a legal error during the trial, or due to the evidence becoming inadmissible, or witnesses no longer being available, or other procedural errors. This is what many people refer to as being let off on a technicality, although the reality is often far more complex than that phrase suggests. Given that compensation is funded by taxpayers, they argue it should be reserved only to those factually innocent, which is right. However, this approach fundamentally misunderstands the purpose of compensation and overlooks a fundamental reality of miscarriages of justice. Innocent people often face immense difficulties in overturning wrongful convictions, and even when they succeed, they may have no new evidence capable of proving their innocence beyond doubt. The absence of such evidence does not mean they are guilty. It simply reflects the practical challenges of revisiting events that may have occurred many years or even decades earlier, or that they have not occurred at all. Critics of the current system, on the other hand, argue that compensation should not depend on proving innocence. They point out that criminal trials do not require defendants to prove innocence. The burden rests entirely on the prosecution to prove guilt. When a conviction is quashed, the individual once again benefits from the presumption of innocence. Why then should the same individual be required to prove innocence in order to obtain compensation? For some time now, we have been highlighting the shortcomings of the current scheme and have developed proposals for reform, which remain available on our website. I will return to some of those proposals shortly when we consider what a fair and effective compensation system might actually look like. However, we are certainly not alone in calling for change. The debate surrounding compensation for miscarriages of justice gathered significant moment last year after the Law Commission published a consultation paper as part of its review of the law relating to criminal appeals, attracting the attention of lawyers, academics, campaigners, and organizations working in this field. Among the most prominent is Appeal, which has been particularly vocal in criticizing the current compensation regime. Appeal argues that the law has created what it describes as a compensation gap. Put simply, a person can be sufficiently innocent to have their conviction overturned, yet insufficiently innocent to satisfy the compensation test. Appeal rightly highlights that this fundamentally undermines one of the cornerstones of our criminal justice system, the presumption of innocence. Once a conviction has been quashed, the state should not require an individual to prove their innocence before compensation can even be considered. This is a position with which we wholeheartedly agree, and one that closely reflects the concerns we have been raising for a number of years. As per the Law Commission, question 99 of its consultation paper specifically addresses compensation for miscarriages of justice and the exceptionally narrow definition currently contained within section 133. At the heart of this debate lies a deceptively simple question. Should compensation be limited to cases where innocence can effectively be proved, or should compensation be available whenever the state has convicted and punished someone whose conviction can no longer safely stand? The Law Commission has already expressed serious concerns about the current test. In its provisional conclusions, it stated that requiring applicants to demonstrate beyond reasonable doubt that they did not commit the offence imposes an unjustified and often insurmountable burden that conflicts with fundamental principles of both civil and criminal law. Its proposed solution is to lower the standard from proof beyond reasonable doubt to proof on the balance of probabilities. In other words, rather than proving innocence beyond reasonable doubt, applicants will need to show that it is more likely than not that they did not commit the offence. While this would undoubtedly represent an improvement on the current position, we believe the proposal lacks the boldness required to address the underlying problems, as we highlighted in this video. The difficulty, however, goes even deeper than the standard of proof. The fundamental problem is the assumption that innocence should be proved at all. Our criminal justice system has never required individuals to prove their innocence. It is built upon the opposite principle. The prosecution must prove guilt. If it cannot do so, the individual is entitled to be treated as innocent. That principle should not suddenly disappear when compensation is considered. For that reason, we believe compensation should be awarded automatically whenever a conviction is overturned, unless there are clear and specific reasons why compensation would be inappropriate. For example, where there has been a subsequent admission of guilt, or where the conviction was overturned solely because of a procedural irregularity that leaves no realistic doubt as to the culpability. Compensation should not require a second adversarial battle. The Court of Appeal should determine entitlement at the same time it overturns the conviction, in our view. The question should then move to an independent assessor whose role is simply to determine the appropriate level of compensation. Such an approach would not only be fair and more efficient, but will also demonstrate a genuine commitment to accountability when the justice system gets things wrong. Now, to complete the picture, It is worth noting that amid growing criticism, in July 2025, the government announced an increase in the statutory compensation cap, raising the maximum award from 1 million to 1.3 million for those who have spent 10 years or more in prison. That sounds good until you realise that the cap hasn't been raised in nearly 20 years. In real terms, it's barely catching up with inflation. But more importantly, a higher cap is of little practical value if the vast majority of exonerees remain unable to qualify for compensation in the first place. And that brings us back to the Horizon scandal. One reason Horizon has become such an important case study is that it exposes many of the weaknesses campaigners have identified in compensation systems more generally, even after convictions have been overturned, even after wrongdoing has been publicly acknowledged, even after bespoke compensation schemes have been created, victims continue to report delays, complexity, uncertainty, and frustration. But what's the reason behind it? Sir Alan Bates has been particularly critical, arguing that government should never have been responsible for administering compensation scheme arising from failures in which public institutions were themselves implicated. That criticism raises an important question. Can the state ever be regarded as a truly independent decision maker when determining compensation for harms caused by the state itself? Bates and many others, we included, argue that compensation should instead be administered by genuinely independent bodies capable of commanding public confidence. Whether one agrees with that proposal or not, the Horizon experience demonstrates something profoundly important. Compensation is not simply about money. It is about trust. Trust that mistakes will be acknowledged. Trust that victims will be treated fairly. Trust that those who have suffered life-changing injustice will not be forced into yet another battle simply to obtain recognition of the harm they have endured. So what should a fair compensation scheme look like? At the very least, the innocence requirement should be removed. Compensation should be accessible, transparent, and independent. Decisions should be made promptly. The process should be non-adversarial. And above all, it should recognize the people whose convictions have been overturned should not be forced to spend years fighting a second battle for justice. Miscarriages of justice are often described as the greatest failure a criminal justice system can commit. But overturning a conviction is only the beginning of putting that failure right. The harder question is what comes afterwards. What does society owe someone whose liberty has been wrongly taken away? What responsibility does the state bear when it has imprisoned the wrong person? And when does justice truly end? The Horizon scandal has forced these questions into the national conversation, but they extend far beyond Horizon itself. For every high-profile miscarriage of justice that captures headlines, there are many others that pass largely unnoticed. Many exonerees leave court with their convictions quashed, but their lives still in pieces. Some emerge after years, even decades of fighting, only to discover that the system which wrongly convicted them now expects them to fight all over again for compensation. That cannot be right. A justice system should not only correct its mistakes, it should take full responsibility for them. I hope you found this video interesting, and if you believe that this issue deserves greater attention, I would encourage you to support the work being done by Appeal and contribute to the greater debate. And of course, don't forget to like and share this video. Join us again as we sit and rise in this unique trial.